I think the judgment may have surprised many because when they look at Ben Roberts-Smith, when he first issued proceedings, he was Australia's most decorated war hero still living. He'd been Father of the Year. There'd been many photographs of him meeting the Queen, meeting the Governor-General, meeting Prime Ministers. He was the public face of the Defence Department. So he issued proceedings. I think that he was very confident when he issued proceedings. He was very confident that a lot of SAS soldiers would not get in the witness box to give evidence against him. But those who read the media, the court reports from the 110-day trial, day after day would have read a lot of very negative publicity. There were new revelations almost daily. And so a lot of people would have seen that damaging material, but they probably also realised that defamation laws in Australia are very pro-plaintiff. They would have recognised that Ben Roberts-Smith was being funded by Kerry Stokes with unlimited resources and were throwing unlimited resources at us. They would have seen the PR machine for Ben Roberts-Smith very active. So there were a lot of articles that were attacking the Sydney Morning Herald and The Age and the Canberra Times and Nick McKenzie and Chris Masters. So they wouldn't have been surprised if the decision went either way. But the reality was Justice Bosanko sat there for 110 days. He saw all of the witnesses in the witness box. He took a view on the credibility of each witness and came out with a really comprehensive decision in our favour. There are a number of defences available to the media in defamation cases. The reality is there's really only one defence that's meaningful, and that's to prove truth, to plead truth, to prove truth. There are other defences: contextual truth, qualified privilege, honest opinion, these sorts of defences, but they might read quite well when you look at them in the Defamation Act, but the reality is they've been read down by the judiciary. And so it's very difficult for the media to succeed in those defences. It is very difficult for the media to win a defamation case. And we've seen that time and time again. I think that a lot of defamation lawyers acting for the media will be looking very closely at the decision in the Ben Roberts-Smith case. We'll be looking at the evidence that we presented, the strength of the evidence that we presented, the amount of work we did in research and putting together all of the documents and other material and putting that before the court. And they will see that if it's possible in their particular case to do the same, then the best way for them to proceed is on a truth defence. There are many people who have issued proceedings for defamation in the past, rich and powerful or people with huge egos, who have assumed that the media would settle on a commercial basis rather than proceed to trial. I think the Ben Roberts-Smith case shows that on occasion, the media will decide to actually stand up and support their journalists, support their mastheads and fight. And that has to be a warning for potential plaintiffs in the future. They might not think that the media will be able to get the evidence into court to defeat their claim, but defamation cases really are a lottery. You can't really anticipate what's going to happen. and it could be the worst mistake they ever make. Clearly, the litigation is very expensive. Clearly, it's in open court. Clearly, it will get a lot of media coverage, and the defamation case could cause far more damage to their reputation than the original publication.